So for those of you who I haven't had the pleasure of meeting yet, it's nice to meet you. I'm Stephanie Lewis, counsel in our Ottawa office. My practice focuses on all areas of employment law that impact provincially and federally regulated employers. Today, I'm joined by our Ottawa employment team and a very special guest. So our speakers today are Catherine Coulter, who you all undoubtedly know very well, Julia Dale, the excellent and brilliant team member who was here when I joined a few years ago, Maggie Sullivan, who recently completed her articles with us and impressed us so thoroughly that we brought her back and are so delighted that she agreed to join our team, and a very special guest, drum roll please, Colleen Hoey. So Colleen is going to be joining our team on September 26th, and we are absolutely delighted that even though she has not quite started with us, she's agreed to come speak with you today so she can meet some folks. Today's webinar is going to cover a number of interesting topics, including what's new and exciting in employment law, hybrid work where we are now, employee terminations through the lens of employee side counsel, termination law updates, and best practices when starting the employment relationship. So our first presentation on what's new and exciting in employment law is being delivered by the fabulous Catherine Coulter. And while many of you have known Catherine for years, an interesting fact about Catherine is that on Sunday of this week, so just 4 short days ago, Catherine and her partner George were the only 2 people in Auyuatuk, I Googled that so I would pronounce it, Auyuatuk National Park in Nunavut. Much to our relief, she survived not only the polar bears that were wandering about the park, but also George, who wanted to fire their bear banger at Catherine to see how it worked. Catherine, we're really glad you're back in one piece. Over to you for what's new and exciting in employment law.
Thank you very much, Stephanie. Hello, everybody. Let me dive right into it. What's new and exciting in employment law? We're going to start with the wild and wacky world of class action litigation today. And that is the case of Fresco and CIBC, which is a 2022 case out of the Ontario Court of Appeal. It's a class action overtime claim that was made against CIBC. And believe it or not, it was issued 15 years ago, way back in 2007. Now, CIBC is federally regulated under the Canada Labour Code rather than under the Employment Standards Act of Ontario, of course. But the legislation, as you'll see, is quite similar to the ESA. This particular piece of class action litigation has been winding its way through the courts for 15 years. There were a number of motions, then the certification process, and most recently, there was a set of appeals brought by CIBC arising out of summary judgment motions brought by the parties. Now, what's this all about? CIBC had a couple of overtime policies in place that were subject to litigation, and which essentially said that management approval of overtime was required before overtime would be paid. Makes sense. Lots of companies have those sorts of policies. However, oftentimes overtime approval couldn't be provided because it was a last-minute thing, and as a result, many of the bank's employees worked extra hours without pay, which is contrary to this Canada Labour Code. And that's where this class action litigation comes in. Section 174 of the Canada Labour Code states, and I've set it out here, that when an employee is required or permitted to work overtime, they're entitled to overtime pay, in a nutshell. The motions judge granted judgment to the plaintiff on liability, finding that the employees were indeed permitted to work overtime, even if approval wasn't granted in writing. And as a result, they were entitled to overtime pay. And so what we have is the motions judge explaining the cases interpreting Section 174 of the Canada Labour Code. And those cases have generally viewed the section as a worker protection provision, in which the word permitted means allow or fail to prevent. And there are a number of takeaways from this particular case in terms of the interpretation of the word permitted. So the Canada Labour Code imposes liability for overtime whenever it's permitted, even if it's not required or authorized. The intent of the code is to protect employees who are simply allowed to work overtime without pay. Next, an employer can't simply look the other way when an employee is working beyond standard hours and then claim that the work was not required or permitted. There are other points as well, but I know we're on a tight timeline here, so let's move on. In February of this year, sorry, not the next slide though. In February of this year, the Ontario Court of Appeal accepted the motion judge's interpretation of Section 174, which means that if an employee works overtime and a company tries to look the other way or to rely on policy wording, which says that you need written permission, or says that the overtime wasn't required or permitted, overtime pay is still going to need to be provided. There's no way around it. And why is this important? Well, we've got some Canada Labour Code employers on the call today, but we also have a lot of provincially regulated employers on the call too. And in Ontario, Section 17 sub 1 of the ESA has almost identical language. It states that subject to subsections 2 and 3, no employer shall require or permit an employee to work more than a certain number of hours. And we know those hours to be 8 hours a day or 48 hours in a work week. In short, the language is almost identical, and the Ontario Ministry of Labour has agreed with this sort of analysis as well. It's okay to have a policy like CIBC had, but it's really important to understand that this is not going to bail out companies if overtime claims are made. It may not be much of an issue for certain types of employers in limited circumstances. For example, if you're an IT company and most of your employees are information technology professionals who are exempt from the hours of work and overtime provisions of the ESA, you probably don't need to worry about this. But for everyone else, you can't just hide behind the policy if overtime hours are worked. As you will know, as of last October, all employers with 25 or more Ontario employees are required to have a disconnecting from work policy. The requirements to that policy under the ESA don't actually have a lot of teeth to them. However, you may want to consider the fact that taking seriously that policy which you have may also help to shield you from overtime claims. The best way, however, to protect against overtime claims is to keep overtime firmly within your radar. And so what I would recommend is that for all but exempt employees, you may want to consider requiring your employees to enter their worked hours into the system on a weekly basis. If people are working overtime, they're going to need to report it. And if they report it, you're going to be able to figure out pretty quickly whether or not someone was authorized in writing to perform overtime. If not, you can have discussions with the employee, and that can lead to warnings if the behavior continues. In short, rather than turning away from tracking overtime, I recommend that you keep a very close eye on it going forward. If I could have the next slide, please. While we're in the land of class actions, just a quick note about a volunteer class action that was recently certified and immediately settled afterwards. In June of this year, the Ontario Court certified a class action against a company called S-Trip. The class action was brought by a number of so-called student volunteers, and they were university-age students who accompanied high school students on trips abroad. They all signed contracts which designated that they were volunteers rather than employees. Some of them received an honorarium of about $150 a week for their work, but that was it. Most were told to expect about 14 hours of work a day. And the company clearly thought, at least, I can't read between the lines, but my suspicion is the company thought that a trip should be enough compensation for these volunteers, even though the reality is that they were all working constantly and weren't able to enjoy the trip in the way in which those under their care were. There was ultimately an investigative story by the CBC in 2017 that led to the class action being issued. And as soon as the claim got certified this summer, the travel company quickly rushed to settle. The settlement was basically calculated on the basis of minimum wage times 8 hours a day times the number of work days for each employee. And the reason that this is important is that for anyone who attended this webinar that we do annually about 7 or 8 years ago, you may recall me talking at the time about the fact that the Ontario Ministry of Labour was cracking down on classifying university students as unpaid interns. Classifying people as volunteers is really akin to that sort of practice. At the end of the day, if you have improper classifications, whether it's for the purposes that we talked about with respect to overtime and improperly classifying employees who may or may not be entitled to overtime, you run into similar sorts of issues with volunteers and unpaid interns, where they effectively lose their standard employment law rights, such as minimum wage, vacation, public holidays, overtime, and termination entitlements. And you should be aware, if you're not already, that there are several largely Toronto-based firms that are making a living nowadays out of issuing class action claims in relation to all these sorts of items: misclassification of workers, unpaid overtime, and unpaid vacation pay. At the end of the day, the good rule of thumb is to treat everyone as an employee unless they are a genuine independent contractor. And you should be providing them with their employment law entitlements as well. Not only is it the right thing to do, but as can be seen from these cases, it also reduces the risk of claims being made. Can I have the next slide, please? The third item on the agenda for me today is the new Working for Workers Act 2022, or Bill 88 as it's called. This is not to be confused with the Working for Workers Act 2021. You may recall that legislation, which led to the requirement for a mandatory disconnecting from work policy, and which indicated that with a couple of exceptions, non-competition provisions are no longer allowed in Ontario. Bill 88 is not that piece of legislation. This does 3 other things. So the first is that it enacts something called the Digital Platform Workers' Rights Act, which establishes a minimum wage for digital platform workers. Those are people like rideshare drivers, food delivery drivers, and couriers, and it's going to give them a certain minimum wage. It's going to prohibit tips from being withheld, and so on. I won't spend any more time on that because it does not apply to most of you. But what is going to apply to the majority of people on this call, and if I could have the next slide, please, is a new section added to the ESA entitled Written Policy on Electronic Monitoring. Under that, and many of you will be aware of it now, employers with 25 or more employees in Ontario are going to be required to have a written electronic monitoring policy in place as of October 11th at the latest. That policy is going to need to include a couple of things. Information regarding whether the company is electronically monitoring its workers. If so, a description of how that monitoring is performed and under what circumstances, and the purpose of collecting that information. The electronic monitoring policies must be dated. They must track the dates of any amendments. Employers must provide copies of the policy to all employees, including those assigned by temporary help agencies. And it also must provide any amendments to existing policies to all employees. This is going to impact things like employee email, chats, Zoom calls, Teams, GPS, keystroke monitoring. The list goes on. It's actually quite a complex area given all of the various technologies at play. And as a result, and as has just been posted in the chat, Dentons, Ontario's employment law team has created a template policy on electronic monitoring with an accompanying FAQ, which is being made available to clients for a fixed fee. And if anyone is interested, please do reach out to any one of us after today's webinar. We'd be happy to arrange that. Can I have the next slide, please? The last thing that Bill 88 is going to do is to dramatically increase applicable maximum fines for violations of the Occupational Health and Safety Act. You've got them listed there. It's also extending the limitation period for instituting prosecutions from 1 year to 2 years. Just a quick note for you to be aware of. Can I have the next slide, please? The next item is also something that I'm just going to touch on very quickly, and that's Bill 96. For those who haven't heard about it yet, Bill 96 was passed in Quebec earlier this summer, and it requires a number of significant French language steps by employers who have any employees in the province of Quebec. One of the key items for you to all be aware of, and this applies to all employers with even just one Quebec employee, is that employment contracts now have to be provided to employees in French. Once that's done, the employee can elect to accept an English language contract instead, but they have to first be given a French language contract before they make that election. And what that means is that for every employee that you have in Quebec that's hired going forward, you have to have a French translation of that particular agreement. Now, I'm not an expert in Quebec law. I'm not called in Quebec. I don't want to lead anyone astray, but I did want to let you know about the existence of Bill 96 and that particular key requirement. For further information, I'm going to suggest that you take a look at the link that's on the PowerPoint. That was an insight published by 4 of our colleagues earlier this year. And my recommendation is that if you have any further questions about Bill 96, you reach out to them directly. As well, if you need any help having any of your Quebec employment contracts translated to French, you can reach out to them. Can I have the next slide, please? So, farewell to the deemed infectious disease emergency leave. This expired on July 31st of this year. It's important to remember that what we call the deemed infectious disease emergency leave under Ontario Regulation 288 sub 20 is different than the infectious disease emergency leave under section 50.1 sub 1 of the ESA. That's a lot of words, that's a lot of numbers, and I'm sure everybody's head is spinning round about now. Let me explain. The IDEL under the ESA, under section 50 of the ESA, remains in place, and that provides and continues to provide a protective leave to anyone who cannot work due to personal medical reasons or family medical reasons related specifically to COVID. That's in existence. However, the deemed IDEL, which disappeared about 6 weeks ago, was the protection for employers against constructive dismissal claims for placing employees on unpaid leave for financial reasons arising out of COVID-19. It's gone now, no longer exists. That means that if you still had any employees on unpaid leave due to a failure to be vaccinated or for COVID-19 related economic reasons, they should now be on a temporary layoff under the ESA if you don't want them or can't bring them back to the office. Alternatively, they should have been returned to work or had their employment terminated without cause. If you've moved them to temporary layoff or are frantically going to do that after today's session, keep in mind that under the Employment Standards Act, the maximum temporary layoff period is 35 weeks out of 52, provided that you've continued benefits for that period of time. And if you haven't continued benefits, it's much shorter. It's just a 13-week period out of 22 weeks without benefits. So for any employees who are switched to a temporary layoff under the ESA after the IDEL came to an end on July 31st, they're either going to need to be returned to work or terminated without cause when that 35-week period or 13-week period comes to an end. What I would suggest is that for anyone impacted by this, it would be a great idea to put a huge reminder in your calendar about 1 month before your temporary layoff period ends. If you don't get out ahead of the issue, it'll mean that anyone not recalled by the end of the temporary layoff period will be deemed to have been terminated and will be entitled to a package at that point in time. Can I have the next slide, please? I'm going to now speak briefly about workplace investigations. One of the reasons that I'm talking about this is that the recent Ontario Court of Appeal case in Render and ThyssenKrupp out of the Ontario Court of Appeal is actually a case that favors employers for a change. In this particular case, the courts have moved from assessing the severity of sexual harassment towards treating each incident of sexual harassment as serious, which is great. It's great news for the people making the claims, but it's great news for employers who may need to terminate for cause as a result of improper conduct. In this particular case, Mr. Render was engaged in a very unfortunate incident where he slapped a female subordinate on the buttocks. He had been employed for 30 years at that point in time, and there was no prior discipline, but he was immediately terminated for cause. The company had a zero tolerance policy in place, which is a good thing to have. And although male colleagues often slapped each other on the buttocks, and there was a lot of sexually suggestive bantering and jokes in the workplace, the Ontario Court of Appeal upheld the trial judge's decision and found a couple of things. Firstly, employers do not have a duty to consider less severe sanctions before terminating in cases such as this. And secondly, termination is justified as long as the termination is proportionate to the severity of the conduct. So great news for employers. Next slide, please. The next case, McGraw and Southgate, is also a workplace investigation case. It's actually a little bit earlier. It came out in late 2021, but after our webinar last autumn. This one's important because it emphasizes the need to fairly conduct an investigation into allegations of inappropriate workplace behavior. But not only did I want to include it for that reason, I thought it was a good way to end the what's new and exciting portion of the webinar, because in each year, for those of you who have attended in the past, you know that I like to give you a case with facts that make your head spin or blow up. And this is one of these cases. So let's get into the meat of it. Ms. McGraw was an administrative assistant and volunteer fire captain of the Dundalk Fire Department. She was ultimately terminated without cause. That's of note, one would think, but it really had no bearing whatsoever on this case. Although she was terminated without cause, her termination arose from years of workplace gossip arising out of her behavior. As a result, she brought a claim for additional common law notice, but more importantly, she claimed moral damages, damages for defamation, damages under the Human Rights Code, and punitive damages. And as you're going to see, she was successful with all of it. So what makes this case interesting and makes your head explode? It's the nature of rumors and accusations and the fact that they were almost all based on hearsay. She was accused of sending inappropriate photos of herself to colleagues. She was accused of engaging in inappropriate workplace relationships of a sexual nature. She was accused of trading sex for grades while in the course of teaching at the local fire college. She was accused of ruining morale. She was accused of causing attrition at the fire station. She was accused of impacting the general reputation of the fire department in the community. And she was accused of being the reason why 2 of the married volunteer firefighters were fired, allegedly because of affairs that she had with them. Clearly, she was not well liked by her colleagues, as these were incredibly vicious rumors and accusations. And so an investigation took place. And with all of that to go on, you would have thought that there would have been a proper, fulsome investigation. But instead, the fire department's investigation was a single memo and some handwritten notes. There were no witness statements obtained. There were no witness statements provided. Even the complainants didn't provide anything in writing. And probably most fatally, Ms. McGraw was not even interviewed in the course of the investigation. Ultimately, that one-page memo relied almost exclusively on inaccurate and dated secondhand information. At the end of the day, even if some of the accusations had been true, there was no way for anybody to know due to the shoddy workplace investigation, if you can even call it that. So, needless to say, as you'll see at the bottom of the slide, the judge found in favor of Ms. McGraw and awarded her 6 months of notice, $75,000 for moral damages, for conflating gossip with facts during the course of the investigation, $35,000 for damages for discrimination under the Ontario Human Rights Code, as her termination was founded on sexist allegations and she was subject to a toxic male-dominated workplace, $20,000 for damages for defamation, as the Sex for Grades comment was admitted on the stand to have been made up by somebody, and $60,000 for punitive damages, as the treatment of Ms. McGraw was found to be reprehensible and a serious departure from ordinary standards. The case wasn't appealed, and it therefore stands as the great quintuple whammy of damages in the past year in Ontario. It also stands as a terrific reminder to investigate fairly, even when terminating an employee without cause due to improper conduct. And when it comes to workplace investigations, don't forget that Stephanie and Julia are both highly experienced workplace investigators if you ever have need of somebody independent who will do the job right. Lastly, and I think I have 1 minute left, I don't have a slide for this final topic because it's so hot off the presses, but I'd be remiss if I didn't touch on the announcement yesterday by the Prime Minister in relation to the September 19th holiday. This is, of course, a new one-time public holiday to take place for the funeral of Queen Elizabeth. There was some confusion over this because things kept changing yesterday. And of course, the federal government does not have jurisdiction over provincial employment matters. But as of the end of the day yesterday, it appears that this holiday will only apply federally to employees in the federal government. It will not apply to federally regulated employers such as telecoms, railways, banks, or airlines. They can opt in if they choose, but they are not required to follow that public holiday. And Prince Edward Island is the only province so far which has announced a one-time statutory holiday. Alberta has not made an announcement yet, as of about 45 minutes ago when I last checked. And all other provinces have indicated that whilst government offices and or schools may be open or closed, depending on the province, there will be no paid or unpaid statutory holidays for regular employees in those provinces. Thank you very much. Brought it right in on time at 9:30, and I will happily pass the torch back to Stephanie. Thank you all.
I sincerely hope that was excellent, Catherine. Thank you. I sincerely hope people's heads didn't explode after your explanation of the McGraw case, because there's so much to unpack there. Excellent use of the word quintuple. And I have some questions about what the land of class actions looks like. I mean, I hope there's subsidized Tylenol available for all the employers who work there, who reside there. Next up, we'll be hearing from Maggie Sullivan, our returning team member post articles and newest lawyer. Maggie, I knew I liked Maggie right away because you'll notice if she's working from her home office this morning that her bookshelf is color coordinated. It's a rainbow. So automatically I knew she was a person that I would like. And in the spirit, another interesting fact about Maggie is that in the spirit of team members who go on exciting adventures, Maggie's interesting fact is that she once traveled to New Zealand and bungee jumped off the third largest bungee jump in the world, which I find terrifying, but clearly she has no fear and will fit in well in our group. From wild adventures abroad to navigating the realities of hybrid work, over to you, Maggie, to tell us more about hybrid work and where we're at now.
Thank you, Stephanie. I am in the office today, so you can't see my my rainbow bookshelf, but we're clearly demonstrating hybrid work in present time with me in the office and my colleagues at their home offices. So I'll just get right into it. Hybrid work has become the new reality for many workplaces, and this has brought up several legal questions. The first of which likely is, how can employers handle changes to the terms of employment? And so when the pandemic started and employees began working remotely, this was undoubtedly a change to the status quo of how we work. And now, as businesses are reopening and employers are possibly recalling employees back into the workplace, this is now another disruption to the status quo that was established during the pandemic. So in light of this, employers should approach these changes to their employees' working model with transparency and open dialogue. Even beyond any obligations that employers may have to accommodate employees due to protected human rights grounds, simply being open to the concerns or the preferences of your workforce is certainly a best practice. We're operating in a rather employee-friendly market where employees are becoming much more selective about their working conditions and the things that they value in employment. The Globe and Mail had a terrific article on this in early September, where hiring experts noted that they're seeing a growing trend of employees leaving their jobs after being required to return to the workplace on a full-time basis. The CBC had followed up with a recent article as well, where Colliers Canada reported that the percentage of employees returning to the workplace on a full-time basis, so in the office 5 days a week, has actually increased from 33 to 37%. But that's not a big number, especially compared to where we were at pre-pandemic. So the numbers do show signs of change, but they're still quite incremental at this stage. In that article, the Strategic Research Alliance also estimated that office occupancy numbers in Toronto are at least 30% less than pre-pandemic levels. And while that's a bigger number than the Colliers number, it still means that a lot of employees are working from home on a full-time or at least a part-time basis. Next slide, please. And so here we see a survey from February 2022, which involved more than 22,000 employees around the world. And it indicated that 15% of employees would leave their jobs if forced back into the workplace 5 days a week. And the graph on the right shows some of the reasons why employees value working from home or value a hybrid model. And of the employees who would leave their job if forced back to come into the office full time, that percentage of Canadians was higher at 22%. So in light of all this, open communication is certainly a best practice. Next slide, please. Another best practice is to provide advance notice to your employees before implementing any changes. As I've mentioned, people have adapted to their pandemic work life routine and their schedule. And so letting employees know well ahead of time that a new model may be instituted is important so that they can prepare. Flexibility is also very important and very valued for on the employee side. You may want to be flexible with traditional work hours, for example, or if your model involves having employees come into the office 3 times a week, be flexible with respect to what those days are. Just talk to your employees about proposed changes, get their input rather than talking at them. And then employers should also aim to ensure equitable treatment of their employees. As mentioned previously, there may be employees who require accommodation due to protected human rights grounds, such as personal or family medical issues. And there also remains some statutory leave protections when it comes to COVID-19 health issues, which employers may need to keep in mind. So in this respect, the in-person or the hybrid work model may not be an option for everyone. I won't get too much into this, but Catherine wrote an excellent insight on accommodation and return to the workplace in June. That's hyperlinked here if you want some more information. Next slide. And so the last point I will mention on handling changes to the terms of employment is that employers should be cognizant of what their employment contracts provided for pre-pandemic. So if a particular work structure was in place pre-pandemic, and the employer is now unilaterally changing that and instituting a new work structure, an employee may assert that this is a fundamental change to a term or condition of employment, and thus they've been constructively dismissed. Similarly, if an employee was permitted to undertake a certain work structure or even work in a different jurisdiction during the entirety of the pandemic, without being told that the company had a right to revert that model once the pandemic started to change and we're going to return back to work, the passage of the last 2.5 years during the pandemic may also lead to a constructive dismissal claim. And these potential claims can certainly be addressed through sufficient advance notice of the change back or of the change to a new model, such as hybrid work. But this will certainly need to be done carefully. Next slide, please. So another concern that employers may have is how they can monitor employees while employees are working remotely. Even when working from home, employers have an obligation for non-exempt employees to ensure that they're not exceeding a certain amount of hours worked in a week, and that if they do work in excess of those hours, they be paid overtime. So in light of this, it's encouraged for employers to foster a healthy work-life balance for their employees when working from home. Employers should remind their employees to take their scheduled breaks and to stop work at the end of their proper workday. They should avoid contacting employees outside of their scheduled work hours, check in on their capacity, etc. Even more importantly, it may be prudent for employers to create a hybrid work policy, which provides that employees must only work for a certain amount of hours each day, that they must take their scheduled breaks, that they have to log their hours, for example. And on this, I again want to add the caveat that employers should not insert any changes into a policy that are contrary to an employee's employment contract. And on this topic, I should also mention Ontario's disconnecting from work policy, which Catherine briefly mentioned. And so I'm sure you all know about it by now, but as a reminder, the province instituted a requirement for employers with more than 25 employees in Ontario to have a disconnecting from work policy. At this point in time, the only substantive requirement is that there be a policy in place, but there's no requirements for what that policy must contain. And similar to the electronic monitoring policy that Catherine also mentioned, the Dentons Canada Employment and Labour Group has developed a ready-to-use template policy. And so if you require one of those and you haven't done so yet, just please let us know. We're happy to provide you with that. And as Catherine also mentioned, having this policy and having a hybrid work policy can help ensure employees are abiding by their obligations, but it's also equally important for employee morale, burnout, and mental health. Next slide, please. Another concern that, or another topic that employers should turn their minds to is workplace injuries when employees are working from home. So the WSIB in Ontario tells us that both employers and employees have the same rights and responsibilities in the event of a workplace injury or illness when employees are working from home. Of course, though, not every injury that happens when employees working from home is a workplace injury. So for example, if an employee is injured while doing their laundry or while taking out the garbage, that's certainly not a workplace injury. However, an employee possibly cutting their hand on a letter opener when working from home might lead to a different conclusion. In Ontario, it is really the WSIB's responsibility to determine the work-relatedness of a claim, and in any event, possible work-related claims should always be reported. The reality really is that this is a very underdeveloped area of the law, and I'm sure we will see more developments on this into the future as remote and hybrid work become more permanent. And just for your information, in a recent 2021 Quebec decision, a judge did conclude that an employee suffered a workplace injury when she fell down the stairs in her home while heading to her lunch break. And while we have not seen anything like this in Ontario, case law on the subject is bound to emerge at some point. And in the same vein as the other items I've previously mentioned, it may be prudent for employers to incorporate safety standards and injury and accident reporting requirements into a hybrid work policy. Next slide, please. So the final item I will address is concerns with respect to where employees are working from when working remotely, such as in a different province or even in a different country. And there's several things that employers should consider in this regard. And first are employment law considerations. So if an employee is working in a different jurisdiction from where you operate on a long-term or even a permanent basis, they may be subject to the employment laws of the jurisdiction in which they are located. And so your company may need to register for workers' compensation in that jurisdiction. Employment contracts may be assessed on different standards, and employees' rights upon termination may be different. Several things you may need to turn your mind to here, and so that's important to keep in mind. And then employers and employees both need to turn their mind to visa and individual and corporate tax considerations. So typically when people enter a country and they want to work in that country, they're required to obtain work visas sponsored by their employer. However, this system was really designed for employees immigrating to a country for the purpose of obtaining work. And what we see happening more today is that employees are traveling for leisure, but will simply carry on work for their employer in their home country while they're there. In other words, while the person will be working, the main purpose of the travel is for leisure and not for business. And some countries have really gotten in front of this and are welcome what they're calling digital nomads. So Antigua and Barbuda in the Caribbean, as well as the UAE, have created a nomad digital residence program that allows workers to come into their country on long-term tourist visas while simultaneously performing job duties for a foreign employer. And in these cases, the employees are eligible for healthcare in the nomad country, and there's no risk of individual or corporate taxation. For non-digital nomad countries, however, tax implications will certainly be a case-by-case determination. So for example, Canada and the US have a tax treaty which dictates, among other things, how US citizens in Canada and Canadian citizens in the US will be taxed in certain circumstances. And the purpose being to prevent double taxation of individuals. But this may not be the case with other countries. And from a corporate tax point of view, depending on such things as how long an employee is in another country and what job they may be performing, they may be seen to establish a permanent resident in that other country. And this means that the company would be responsible for paying corporate taxes in that country as well as in Canada. So before you permit anyone to do hybrid work in another country for an extended period of time, it's always best to get tax advice. So as I said, this is really an issue that will need to be determined on a case-by-case basis when situations arise. And again, like the other items I mentioned previously, you can incorporate any policies on working abroad or in a different jurisdiction into a hybrid work policy. So that concludes my segment here, and happy to welcome any questions.
That was great. Thanks so much, Maggie, and anyone with questions for Maggie on that particular topic, which we know is very topical right now and of the moment. You feel free to put them into the Q&A, as well as any questions you may have on any other topics that we are addressing today. In the meantime, I'd like to give a shout out to Peggy Wong, our client development and events specialist, who I don't know if you've all been noticing, but she has been positively on top of posting all the links to things we reference in real time. We didn't practice that. Peggy's just that good. As previously mentioned, we're delighted to be joined today by Colleen Hoey, who's going to be joining our team officially on September 26th. An interesting fact about Colleen is that one of the items on her bucket list is to row a pumpkin in the annual giant pumpkin race in Nova Scotia. While Colleen provided a number of excellent, interesting facts, this one was my favorite because it not only highlights her excellent priorities and sense of fun that you'll undoubtedly get to know as she joins our team, but it also includes an East Coast connection that I love personally as a Newfoundlander. I'm biased. As Colleen speaks to us today, she's in her final days with another firm where she provides both employee and employer side advice. So today she's going to give us a snapshot into the other side of employment files and speak to us about employee terminations through the lens of employee side counsel. So over to you, Colleen.
Thanks very much, Stephanie. I appreciate that. And actually, anybody looking into the pumpkin race, I actually went and looked at it again, and it looks like it's been canceled for a period of time because of a lack of water. So there is talk about other people starting this annual regatta again in another neighboring area, but it is a thing that's been going on since I think over 10 years, possibly longer. And it looks like a lot of fun. So yes, today the purpose of my comments are to provide a window into the conversations that are taking place with employee counsel. It's hoped that this information will help you with your goal of making sure any terminations that you might have to carry out, that they go as smoothly as possible. So when working with an employee, the focus of counsel is very much on that one person and how the termination impacts them. This individualistic perspective and the issues that preoccupy employee counsel are perhaps best summarized by Justice Dixon and later Justice Iacobucci by the Supreme Court of Canada in the case of Canada versus the Coulter decision, and that's highlighted on the screen. Essentially, this case stands for, or speaks to the importance, the fundamental importance of work, how it provides individuals the means of not only just financial support, but their identity and their sense of self-worth, emotional well-being. And these factors often drive a lot of the litigation, but also the emotion that can flow into terminations. The line underneath is also very important, that it's not just the impact on a person's identity, but the manner in which employment can be terminated is equally important. It's important to the council. It's going to be important to the courts that are looking at these decisions or at these cases. And I know that employers are often also very acutely aware of the impact that a termination may have on an employee. However, the employer and their counsel are also typically also balancing other considerations, the business, financial, performance, team dynamics. There's a variety of factors that are leading to this decision. But for the person on the receiving end of the letter, learning that their employment has been terminated, the entire issue is deeply and uniquely personal. And so I was reflecting on this, and I think there's really 4 key elements that impact how litigious a termination might become. The first is the severance package itself. The second are the workplace events preceding the termination. The third is the person's individual circumstances and their personality. This is something you may or may not be able to obviously do a lot about, but it's an important consideration to be mindful of. And the fourth is the manner in which that termination takes place. And so these 4 factors tend to influence whether the person is going to go storming into a lawyer's office looking for everything they can get, or they might come in concerned but prepared to reach a compromise fairly quickly, or they may just come in looking for confirmation that what they have is a good deal and worth taking. It's also true that sometimes, depending on those 4 factors, a person may never reach out to counsel at all. But all of this was brought to mind recently in the case with Lisa LaFlamme, the CTV host who was recently terminated from CTV News and leading to that PR nightmare. What I found interesting about this particular case, if you go on to the brief video clip that Ms. LaFlamme posted on Twitter, you can see 3 of those factors play out in relief. We have the negative events leading up to the termination, including comments about gray hair, age. We have the other factor, when you hear Ms. LaFlamme speaking, how she identifies deeply on a personal level with her job. And finally, and this is an issue something that I hear often when people are particularly upset about a termination, is the feeling of being shocked, blindsided. That's one of the first words that Lisa LaFlamme speaks about, as being blindsided, and saying that she was leaving CTV News in a manner that was not of her choosing. That to her was crushing. So this is not just a business decision to her, it was personal. And of course, employees often do find themselves leaving employment in a manner that's not of their choosing, but those who feel blindsided and humiliated by their termination and the way it is carried out will be much more likely to push back. So one of my recommendations, to the extent possible, is to carry out the termination in a manner that is as graceful as possible. Not in front of others, discreetly. Think about who's in the room, even if it's a small group. The who's delivering the news can matter to the individual who's on the receipt of that news. In some, but not all circumstances, a brief working notice period that allows the employee to wrap up, say goodbye, can be effective. It can also perhaps allow them to author some of the terms under which they depart. I recognize that that's not always possible. Then there's also the communication around the departure. It matters. Make it positive. And then it's a small thing, but it often comes up in conversations around terminations, is the way in which people are given access to their belongings. Giving them the opportunity to come in, perhaps after hours, so that they are able to gather their belongings in a way that does not cause embarrassment is important. Packaging up the belongings and returning it to their home in a way that doesn't look like everything was just tossed in and broken matters. And it's amazing to see small things, but again, at this time, feelings are often very acute, and those types of small matters will become a key focus of employees if they feel that they have been personally disrespected in the process. So the termination has been carried out, what issues are employee counsel going to go over with those employees? In a nutshell, everything from hiring. Were they recruited? When was the contract signed? Were there amendments? If there were amendments, was there consideration given for those amendments, for any changes? Was there a gap in service? Of course, employee counsel is going to look very closely at the contract itself and the termination clause. We'll also go into the personal. What's going on in their lives? Are they undergoing cancer treatment? Are there addictions, mental illness? If that is the case, there is sometimes the opportunity to look at LTD treatment or other solutions. And I would say I've worked with a number of employers in different circumstances where we've been able to manage a transition from employment into circumstances that really are much more beneficial to the employee who in fact is going through a difficult time. The other thing we'll talk about with employees is how easy or difficult is it going to be, do they think, to find comparable employment? If it's the case that they tell me that they've already got a job lined up, well, then that will necessarily impact the conversation about how one moves forward. We'll look at benefits. Are they or someone in their family dependent on those benefits? For some people, those benefits are really critical. We'll also go through that full and final release and the various items that they will have to sign off on. And that's where some of these other elements come up. We'll talk to them about the fact that, have to waive any claims under the Ontario Human Rights Code or under the Canada Human Rights Act. And are there any issues that would prevent them from being able to sign that? What about harassment? Are there any other issues that might preclude them from being able to sign? Also, on the line of the release, sometimes some employers will bake in additional elements in a release that they're looking for, perhaps a non-solicitation clause that's a little bit more fulsome than what's in the contract. If that's the case, then you can anticipate that employer counsel or that employee counsel is going to say, well, if you're asking for more, then there needs to be some additional consideration. So that may become a negotiation piece. We'll also look, of course, at does the package cover everything from wages, overtime. Catherine was speaking earlier about overtime, ESA, proper calculation of severance, not just rounded vacation benefits pay, and that they're provided through the ESA notice period. So even a slight error in the ESA calculations will give counsel a reason to write. And once you have a reason to write, then things can expand from there. Generally, we look at the package as a whole and how much is being offered. If it's ESA only with a very restrictive release, you can anticipate people are going to push back and look for more. If the offer is fair, the benefits are covered, the contract is solid, the advice to clients will more often than not be that it's not in their interest for counsel to push back, and we will recommend signing. This does happen where you know that you cannot provide value added, where you think that it will cost the person more than what they will be able to possibly get. So striking that mid-range balance where it's not financially in the client's interest to push back is a good strategic point, I would say, for employer counsel to aim at, because it helps. It means that there's not a great deal of financial upside to going forward. So one of the other questions that Catherine and I were speaking about is, does giving the employee a reason for the termination, is that beneficial? And I would say, unless there's a mass layoff where it really, really, truly is not personal, I don't find that giving a reason for the termination helps. For example, you've been consistently late, Colleen, and because of this lateness, this has led to this termination. Typically then, if you get a letter which says, well, these are the reasons, the client is going to sit with me and explain why the employer is wrong on all those points. I wasn't really late, or I was only late sometimes, or the person was picking on me and they weren't treating me fairly, or I have a medical condition that causes me to be late. And that then can open up exploration, obviously, of well, is there a health reason for the lateness? Do we have to look into a human rights potential issue here? So I would be inclined, because this is such an intensely personal type of an experience, I tend to find not having a reason keeps it cleaner, keeps it more succinct, and allows counsel just to be able to focus on, okay, it is the case here that people can terminate. They don't need to have a reason. So let's just look at what's fair, what's reasonable, and how do we make sure you can get from this point to the next point. And we don't sort of revisit a lot of that, of the why. What about a letter of reference? Is it helpful? Yes, and ideally a positive one. A good letter of reference can be a balm on emotion. Now, I've had employer clients say to me, well, why would I write a positive letter of reference for somebody I just let go? You know, I've got reasons I want to let them go, or I don't want to be dishonest. And certainly would never want somebody to be dishonest. But to the extent that you can list in a positive way, list the roles and responsibilities of what it was that they did. And typically, I think that one can come up with at least one or two things that the person did well and focus on those two things. A person seeing that there is a positive letter will make them feel less insulted, less hurt. It also, of course, strategically helps the employer because this positive letter of reference will help the person find another job, hopefully, and then they've mitigated their losses. So this is all to the good from the employer side as well. It also connects to a theme that I hear a lot when it comes to releases. And when people read the release, there's usually language in the release about how the employee undertakes not to say anything disparaging about the employer, and like in addition to the confidentiality. And almost always employees will say, well, they're asking me to say that I won't say anything negative about them, but there's nothing to protect me. How do I know they're not going to go out and say all kinds of terrible things? One, a positive letter of reference will help. And then two, to the extent possible, even if it's not baked into the release, if there are minutes of settlement, having those types of assurances where recognizing you can't necessarily control what everybody will say, providing the person with some assurance that they are not going to have their name blackened in the community by negative comments would be helpful, again, as they move forward. The two other pieces, or the one other piece, is the clawback clause. Employees are often offended by the presence of a clawback clause. They will bring that in as an issue of concern. It tends to lead to a feeling that the employer is not being fair or is being stingy. That said, a termination letter which makes reference to the fact that there is no clawback can be an effective tool in signaling that if the employee comes back and asks for more, that a clawback might, find its way into the negotiations, and that can be that can sometimes help in bringing the employee around. It also helps prompt those conversations about mitigation, because that's not always something that is front of mind for employees when they first come to see counsel. And the other piece I have seen helpful for some employees is where a package offers both a clawback, which is more generous, and then there's a less generous package but with no clawback. And so that can generate some interesting conversations about strategies with the employee. So to summarize, it is the case that some people are just going to be more litigious than others, and no matter what you offer, they'll be coming back for more. But on the other hand, I've had many clients over the years who have said that I think that I'm being treated fairly, both in the manner of the termination and the substance of the offer. And so they are prepared to move forward with the package, even if technically they think they might be able to get more. The relationship matters. So I would say, there's no getting around the fact that this will be difficult in most cases. But if people can treat people as well on the way out as they do when they bring them in, it can go a very long way to avoiding unnecessary litigation.
Thanks so much, Colleen. That was great. We're very much of the same mind when it comes to the way you treat people. I mean, it's like a breakup, right? If you're breaking up with somebody and you want it to be on good terms, you don't want it to be acrimonious, you're not going to say, it's not me, it's you. So I loved that advice. That was fantastic. Thank you. So next, we're going to be hearing from Julia on something that's really important and that we discuss with you folks on a regular basis. Julia's, namely termination law updates, Julia's interesting fact is that when she's not working, she's making music. And I'm not saying that figuratively or metaphorically. She's actually making studio quality songs with lyrics that sound like they could be found on iTunes. She has shared some examples recently, and Catherine and I were positively blown away, and we're trying to encourage her to go mainstream while nevertheless staying a member of our team. And on that note, today Julia is going to be speaking with us about something equally cool and of the moment, termination law updates. Over to you, Julia.
Thanks, Steph. Yeah, everyone loves that friend that plays them their homemade music, of course. So that's me. So we all just heard from Colleen about what employee side counsel look at and consider when an employee walks into their office. And as employer side counsel, what we want when an employee walks into someone like Colleen's office is for Colleen to read the contract at issue and say, ooh, yeah, you have a good enforceable termination clause. But the Ontario courts, as you know, like to make that more and more challenging for us as lawyers and for our clients. So today, I'm just going to give you an update on where the law of termination clause stands now, and especially since the Waxgill decision. Slide, please. So before I get into statutory principles, as you know, fundamental principles are employees are entitled to reasonable notice of termination. And the courts have created common law notice, which is the amount of notice an employee should get based on their age, seniority, qualifications, ability to find comparable employment. Basically, how long will it take the person to reemploy? And common law notice can be provided by working notice, or it can be paid out in lieu. And common law notice, as you know, can be a very high liability. It can be 1 to 2 months per year of employment, usually to a cap of 24 months. Subject to exceptional circumstances that could bring it higher. And the only way to avoid those large payouts of reasonable common law notice is to have an enforceable statutory minimums clause in an employee's employment agreement. And those clauses limit the employee to the statutory notice requirements that are found in the Employment Standards Act 2000. And so the key goal, and something that takes up a lot of our time, is ensuring that our clients have enforceable ESA minimum termination clauses in an employee's contract so that they are not entitled to the larger common law notice packages. So, general principles by statute under the ESA, Section 5A says that no employer shall contract out of or waive an employment standard, and any such contracting out of or waiver is void. So as soon as you undermine the ESA in your termination clause or your wider agreement, we'll discuss that, you risk invalidating the termination clause because you're contracting and undermining the ESA, contracting out of. Section 61 of the ESA says that during a notice period, the employer cannot reduce the employee's wage rate or alter any other term or condition of employment. So in the termination clause, if you say anything that would suggest that the employee's terms of employment are going to change the notice period, or they're going to be getting something lesser than what they would have gotten had they remained employed through the notice period, your termination clause won't be enforceable. Next slide, please. So looking now at what the courts have said about termination clauses, I've put on the slide a quote from Wood and Fred Dealey, which is a leading case on termination clauses. And the court does a really good job of summarizing the principles of how a court treats termination clauses and why they interpret them in the way that they do. I won't read them all, but the key ones being, of course, that employees are seen to have less bargaining power than employers when employment agreements are made. They're not likely to challenge their termination clauses. They're not likely to understand their rights under the ESA to even do so. The ESA is meant to be remedial legislation, and courts will always prefer an interpretation of the clause that gives employees a greater benefit than the employer. And finally, actually, I'll do this on the next slide. So could you go to the next slide, please? Thank you. So here now are some quotes from the courts as to, again, how they interpret employment agreements. Key ones being that the courts will look at the agreement at the time the parties entered into it as to whether it's enforceable. And I'll touch on this later, but it doesn't matter how the employee is terminated. They look at the clause at the time they entered into it. So irrespective of how the employee is terminated, the clause can be, the clause needs to be read on its plain language. The courts are not supposed to strain to create ambiguity where the contract is clear, but then again, the courts also say that a high degree of clarity is required when interpreting a termination clause. And another important one is that if a clause potentially violates the ESA at any date after hiring, the clause will be invalid. So in Rutledge versus Cannon, the court found a termination clause was unenforceable because it didn't provide for severance pay, but the employer was not an employer that would have actually met the threshold required to provide severance pay. They didn't have a payroll of $2.5 million or more. However, the court said, well, one day the company could. And so again, the courts look at the contract at the time of entering into it, and whatever happens after could potentially result in the termination clause being unenforceable. Finally, the courts have said that the reason that courts interpret these clauses so strictly is that they want to ensure that that employers have incentives to draft lawful termination clauses. Next slide, please. And I'm sorry if you're hearing squeaking in the background. My dog has found a chew toy that I should have confiscated before this. So based on the case law we had that I've just gone over, the general principles for making a termination clause enforceable would be that you have to make sure the employee is expressly being provided with applicable statutory notice and severance pay. Again, severance pay is only owing if you're an employer with a 2.5 million payroll or more and the employee has 5 or more years of service, but you still have to provide for it in the termination clause, even if severance pay might not apply. You have to provide the employee with benefits continuance throughout their statutory notice period. Vacation accrual, a lot of contracts don't provide for continuing accrual of vacation pay through the notice period. They cut it off on the last day of employment. That will render the clause invalid. Ensuring that employees are provided with any earned incentives and bonuses through the notice period, because performance bonuses and incentives form part of wages, and you're not allowed, like we saw under the ESA, to change employees' wage entitlement during their notice period. Being careful not to put caps on the potential notice that's going to be offered, because some employers won't account for the fact that on a mass termination, more notice is going to be owing than what you think is the cap, which is normally the 8 weeks for an 8-year employee, and they accidentally cap it too low. So being careful about going beyond the potential or not going to the potential maximum. And then also language is required to limit the employee to only their ESA minimums. You need an express waiver of common law entitlements. The clause actually has to say that you're understanding that you're not getting common law notice. We have to be careful to properly define the probationary period, which is 3 months less 1 day in Ontario. Otherwise, if you say you're going to terminate someone without notice in a 4-month probationary period, well, then you've run afoul of the ESA and risk invalidating the termination clause. Naming the correct legislation in your termination clause is important. Some people will just write the Employment Standards Act or Employment Standards legislation. In Ontario, it's the Employment Standards Act 2000. And finally, employees cannot be required to sign a release for their statutory minimum entitlements. So if a termination clause says you'll be provided with your ESA notice and severance pay in exchange for a release, then you run afoul of the ESA. Next slide, please. So then we had the Waxdale decision, which we've hopefully you've all heard about at this point, and we've sent out lots of notices on it. So this was the June 17th, 2020 decision of the Ontario Court of Appeal that really again, changed the landscape of the law and termination clauses and rendered a lot of termination clauses unenforceable. So in that case, what happened is the employee was terminated without cause, but there was termination for cause language in the employment agreement that cited like a laundry list of conduct that the employer said would be cause. So there was like breach of confidentiality, conflict of interest, things like that. The Ontario Court of Appeal held that the cause language didn't meet the cause definition under the ESA. And under the ESA, cause is an employee who's been guilty of willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer. So unless an employee's behavior meets that standard, they're entitled to their statutory minimums. And the court found that because the cause language undermined the ESA, the entire termination without cause provision was unenforceable, even though the employee was terminated without cause. So, and this was also despite the fact that there was a severability clause in the agreement. And essentially the court said that it's obliged to determine the enforceability of the termination provisions as at the time the agreement was executed, and non-reliance on the illegal provision is irrelevant. So again, didn't matter that the employee was not actually terminated for cause. The for cause language still rendered the without cause language unenforceable. Next slide, please. So then the question, of course, is what amounts to ESA cause? What meets that definition? And so the courts have said that willful misconduct requires evidence that the employee was being bad on purpose. And that's from a recent 2022 decision. And other courts have said that a persistent carelessness won't meet the standard of cause under the ESA, and that it involves a subjective intent level, almost like the criminal sort of mens rea component, where the employee's got to intend to do harm, essentially. And that this is a good quote: careless, thoughtless, heedless, or inadvertent conduct, no matter how serious, won't meet that definition. And while there's ESA cause, there's also common law cause. And so if you have an employee who has committed something that amounts to common law cause, then that employee will not get common law notice, but they'll still get ESA notice because the behavior didn't amount to ESA cause. So then the question becomes, well, what's ESA cause versus common law cause? And common law cause is a lesser standard, and the courts have found that that common law cause can be found on the basis of prolonged incompetence, and it doesn't have the mental element that the ESA cause has. Next slide, please. And so some repercussions of Waxdale are that, one, all employment contracts now need to cite the ESA definition of just cause if you want to be able to terminate your employees without notice for ESA cause. Second, any language now in your employment agreements, throughout your employment agreements, in your handbooks, in your policies, are now at risk of rendering a termination clause in the employment agreement unenforceable, because the courts are clearly looking not just at the clause itself, they're looking everywhere. So you'll see at the bottom the quote from Waxdale where they say it's irrelevant whether the termination provisions are found in one place in the agreement or separated, or whether the provisions are by their terms linked. In that case, they found that the trial judge erred because he failed to read the termination provisions as a whole and instead applied a piecemeal approach. So now when we are looking at employment agreements, we also need to make sure that there's nothing in other documents that are undermining the ESA, and that could render the termination clause unenforceable. Third, there's now this uncertainty around drafting for allowing terminations for common law just cause, because we need to be careful that we've properly defined ESA cause and distinguished it from common law cause. And so adding that common law cause language in agreements is a bit risky because we're starting to play around with the language around cause, and the courts are now being extra diligent about trying to render those unenforceable. Also, like has always been the case, courts look at enforceability at the time of contracting, and Waxdale really reinforced that. It doesn't matter whether the employee was terminated for cause or without cause when you're looking at whether the language is enforceable as a whole. And lastly, court confirmed that severability provisions aren't going to save unenforceable termination language. Next slide, please. So some of the case law that's come out, I won't read these all, but these are some examples of termination clauses that have been found unenforceable as a result of Waxdale. So for example, the first one, Canon Design maintains the right to terminate your employment at any time without notice or payment in lieu thereof if you engage in conduct that constitutes just cause for summary dismissal. So again, there's no definition, there's no ESA cause definition in that agreement, and so the employee would be entitled to their ESA notice. The next one, defendant can terminate without notice should cause for termination exist under the common law of the courts of Ontario. So again, not citing to the ESA definition. And there are some cases, like in the last bullet on the next slide, where like in Waxdale, the employer has listed specific conduct, like conflicts of interest and breach of confidential information could result in termination for cause, and the courts have said that that conduct won't amount to cause under the ESA. Next slide, please. So, oh, here's another example of a cause that was not found to be enforceable, and I won't bother reading it. Next slide, please. So here, I just like this quote because the court acknowledges that, but for Waxdale, this termination clause in this case would have been enforceable, but because of the just cause language being unenforceable and how it can't be severed, the entirety of the clause was rendered unenforceable. Next slide, please. Okay, so apart from the Waxdale updates, I just wanted to give some general updates on termination case law, which have been interesting in the past year or so. This first one, Humphrey v. Maine, there was always a question in the courts as to whether when you're actually paying out termination entitlements and you make a mistake. So some employers will come to us and they've miscalculated severance or forgotten to pay severance completely, whether that actually renders a termination clause unenforceable that was otherwise enforceable because they've repudiated the agreement. And so the Humphrey v. Maine was helpful because it said that technical mistakes made in good faith won't constitute repudiation. So hopefully that means if you do miscalculate severance, and there's other case law to support this, and it's done in good faith, then that's okay. You can still rely on the termination clause. But serious conduct that is in bad faith can lead to a repudiation. And so in this case, I believe this is the one where the employee was treated terribly before she was terminated. They essentially were trying to get her to leave through harassment and other things. And the court actually found that, and then they terminated her for cause, and they tried to rely on a without cause clause in the alternative. And the court said, you can't rely on your enforceable without cause clause because your behavior was so bad that you actually repudiated the entire agreement. So it was no longer enforceable. Another interesting case was Russell v. the Brick. The court found that the way the termination letter was drafted actually resulted in moral damages against the employer because the employer failed to advise the employee that they would receive their minimum ESA entitlements, even if they didn't accept the greater additional package offered. So often in our letters, as you know, we provide the employee with their ESA minimums and make an additional without prejudice offer in exchange for a release. But we always make clear that if they don't sign that release, they'll still get their ESA minimums. And this case really reinforced that that's extremely important. Also in that termination letter, they didn't provide for the proper benefits continuance and RSP continuance throughout the notice period. So even the termination letter has to be very carefully drafted. Next slide, please. Okay, and then a couple more, Rahman versus Canon Design. This case was important because the court found that the employee sophistication and access to independent legal advice didn't assist in making the termination clause more enforceable. The court still just looked to the language of the clause and found it was unenforceable, even though the employee had a say and was negotiating her contract. And then the last case, which Catherine has already discussed, Render. This one was helpful because it talked about the element of what will meet a cause termination. And in this case, the Ontario Court of Appeals said that willful misconduct involves subjective intent, almost akin to what we talked about, which is a special intent in criminal law. And actually, in this case, the court found that the slapping of the female was not ESA cause. And so the employee got their statutory entitlements, but they did find it would constitute common law cause because it was a heat of the moment event. This employee, like Catherine said, had a long period of service without incident. And this workplace specifically was sort of a bit of raucous, and everyone was always kind of joking in this manner. And that didn't change the court's interpretation, but that context led them to find that this employee made a mistake and it was a one-time mistake. And so that case really helps with distinguishing between what is common law cause and what is ESA cause. And this might be my last slide. Let's see. It is. Okay, so that's all for me. Thank you. And if you have any questions, happy to help.
Thank you very much, Julia. That was terrific. Good morning, everyone. I'll just jump in here and add that I'm so glad you've all been able to join us today. Our final speaker is your host today, Stephanie Lewis. And I'd like to thank Stephanie for stepping up to the plate and hosting today. It wasn't clear even as late yesterday whether I'd be stuck up in Nunavut with limited Wi-Fi and cell phone coverage. So Stephanie, thank you for a tremendous job. Stephanie's fun fact is that she recently went to Disney World and Harry Potter World in Orlando and was even more excited by it than her sons were. And her sons are, if I recall correctly, 9 and 11. So that's saying a lot. Not only did she finally get herself a wand, but the entire family now has a family wand holder. So Stephanie is my hero. I want a wand holder too. And her best anniversary ever was celebrated at Hogsmeade with a big mug of butterbeer. Stephanie is going to speak to us today about best practices when starting the employment relationship. And over to you, Stephanie. Thanks.
Thanks so much, Catherine. Just for the record, because I am calling you from home, I did get my wand. I have the Fleur Delacour wand. It was a very big moment for me. And what we're doing today is we're kind of flipping things on their head, and we're concluding the 2-hour presentation with best practices when starting the employment relationship. Peggy, if we can move to the next slide, please. Oh, so this is what, if we have time, we will cover, and if we don't have time, we will come to it, I'm sure, on another day, or I can provide you with information offline. So we'll move on to the next slide just to make sure we get through this on time. So the thing about the rules that govern the employment relationship is that they kick in before people realize they kick in. You know that you're not allowed to discriminate against anybody in the course of employment, and you think employment starts on your first day of employment, or at least that's what I would think if I didn't know better. The prohibition in the Human Rights Code against discrimination, discriminatory hiring practices, extends to the the publication seeking applications, as well as the interview process. So if we look at what under the Ontario Human Rights Code, and we know that the federal Canadian Human Rights Act has similar provisions. It says at 5.1 that every person has the right to equal treatment without discrimination based on any of these 13 protected grounds. So as a matter of best practice, in order to make sure that during the interview process, you're abiding by these rules, it's good to be consistent. So you're asking everybody the same questions. You're not asking people different questions based on their personal characteristics. You're going to document the interactions. You're going to take notes of, you're going to take notes of not only what is asked, but what the answers are in the event that that comes into question later. You're going to maintain these records for at least 2 years. And the reason for that is that there's a 2-year limitation period for bringing a claim. So if anyone was to allege that there was inappropriate conduct, you have access to these records. We know that it's 1 year, it's a 1-year limitation period to bring a human rights complaint. That can be extended. So the safest to do is 2 years. You're only going to contact referees provided by the candidate. And we're going to get into that a little more fully later in our recommended clauses, which include reference check clauses. And if you wouldn't ask the applicant, you're not going to ask their former employer. And I don't think Catherine remembers this, but Catherine and I were on a panel together on October 27th of 2016. And we were presenting on considerations when starting the employment relationship, only in different elements. Catherine had top 10 tips. I was covering the ability to drug test, all of these things. And someone asked whether or not when seeking references, they could ask about people's absences with their former employers when doing a reference check. And Catherine's answer, which was the dead-on right answer, which was there's almost no answer to that question that will not be problematic for you. So you're better off not to ask. If the answer is yes, because they are sick a lot, then you can't decide not to hire them based on a history of illness, because that would be discriminatory based on disability. There's no answer that's the right answer. So for questions like that, we recommend not asking anyone. And I know you're thinking right now, Stephanie, how hard can this be? I mean, those are red flag issues. How hard can it be to stay away from those topics? And it's tricky, right? Because when you're getting to know people, you're getting to know things about them in a normal context. And so often it will come up if someone happens to be married or have children or have a partner or what they like to do for fun that may or may not get into any of these areas. So the thing to remember is that even though we're all nice people and we want to get to know people, we can't be asking these questions in the interview. And even though I've said to document interactions, if someone volunteers without you asking that they have 2 kids or they're married or they have and it's not in the context of discussing an accommodation and they volunteer that they have an illness, don't write that down. Don't write that down. That is a trick. You don't want to be perceived as making any decisions about their employment in relation to any of those things. And you're not going to ask any follow-up questions, which can be tricky because we all just want to be nice and get to know each other. But in the interview process, off limits. And if anyone has questions about that, just let me know. So we'll move on to the next slide, please. So, and I know we're preaching to the choir here because we're speaking to a room full of clients. And so if you're here with us, you most likely have written employment agreements that we have prepared for you or reviewed for you. And what some people don't realize, probably no one in this room, everyone in this room probably knows, is that people have an employment agreement irrespective of whether it's in writing. So the issue becomes defining it and ensuring that people have a mutual understanding of what that entails. The employment agreement, if nothing is in writing, is determined by statute and common law terms. So it can be less certain and can create ambiguity or misunderstandings between the parties. So the reasons we encourage people to have written employment agreements are that they provide certainty and clarity. Everyone knows what the terms are. They reduce the risk of conflict because everyone knows what the terms are and has agreed to them. And they ensure compliance with statutory requirements. So we know that all employers need to comply with the statutes that govern their jurisdiction, including the Ontario Human Rights Code, the Accessibility for Ontarians with Disabilities Act, all of those things, and the Occupational Health and Safety Act. And while we won't go into all of the requirements for what that involves, ensuring the proper language is in the employment agreement will help ensure that people know that you're going to abide by that moving forward. There are certain clauses that need to be in writing in order to be enforceable, and here are some of them. Probationary clauses are an area where a lot of people have misunderstandings. Some people think that because notice entitlements don't kick in until 3 months of employment, that constitutes a probationary clause, and that's not right. Unless there is a probationary clause in a binding and properly executed employment agreement, you cannot have separate terms of employment that apply to the beginning of the employment relationship. So if people want a probationary clause that sets out that people's suitability for the role will be assessed, et cetera, as well as people's entitlements upon termination during the probationary period, you need to put it in the agreement. Of note, people sometimes ask whether they can have a probationary period that is beyond 3 months. And we obviously make the probationary period, as mentioned by Julia, 3 months less a day, because at 3 months you are entitled to notice. You can have a probationary period that's longer, but what you need to have in the probationary clause is once that employees terminated during this period are guaranteed their ESA minimum entitlements, so that there's no implication that they will not be entitled to notice once they hit their 3 months of service. Temporary layoff provisions, again, there's no temporary layoff at common law. So if employers want to be able to temporarily lay off their employees for reasons associated with business shortages or what have you, you need to have that written clause in the agreement. Restrictive covenants. So non-solicitation clauses and non-competition clauses. And I'll make a quick note shortly on non-competition clauses. If you are going to put these restrictions in place and agree to them with an employee, you need to put them in the employment agreement. I do have a spot later in my presentation to address a change recently to non-competition clauses, but I'm going to do it here because I suspect we may not get to that slide if we're going to leave time for any additional questions. As some of you may know, a change was made to the ESA effective October 25th, 2021, which said that employers couldn't impose non-competition clauses in employment agreements for anyone other than an executive. And when you think who's an executive, it's essentially all the C's: CEO, CSO, CIO, CFO. All of the members of the C-suite are most likely going to be considered executives, but everybody else, standard employees, cannot have non-competes moving forward. They will be void and of no use. And if you put a clause in that can't be enforced, there's a risk of other negative consequences on your employment agreement. So there is an exception. So for those of you thinking, I have a number of existing non-competition clauses, what does this mean for me? There was a case called Perec and Schechter where the court of the judge found that the legislators did not intend to strike down all existing agreements. If they had, they would have been explicit and written that into the act. So it's only agreements post October 25th, 2021, where you can't use non-competes. Old non-competes are grandfathered. At the end of the day, it's not a huge change because we know that non-competes are considered restraints against trade, are considered presumptively unenforceable, and the courts were loath to enforce them except for them against the most senior employees anyway. So whether or not this actually makes a material change in practice, I doubt it. And then termination clauses with less than common law entitlements. Julia just did a beautiful job of explaining that. Thanks so much, Julia. And again, just to repeat, if we're going to do that, we need to do that in writing. Next slide, please, Peggy. So general tips for drafting, and I'm going to run through these quite quickly because given that you're most likely coming to us to write it, you don't need the tips. This just gives you an idea, a peek behind the curtain of what we're doing when we're assisting with your agreements. One, plain language is best because you want everyone to understand what you're writing. It can be really tempting to break out all your $10 words, but if no one can understand it or it's exceedingly complicated, it's just like having nothing at all. if we are asking you for copies of your written policies and procedures in the context of preparing an agreement, it's because we want to ensure consistency. If there is any kind of a conflict between the employment agreement and a policy, it can create an ambiguity. And in cases of ambiguity, courts will construe things against the employer because of the power imbalance between employers and employees. And so we always put it in the event of a conflict between this and any policy this agreement will govern. But if we're asking, and particularly if we're asking for terms of a bonus plan or terms of an option plan, if we're not writing in your employment agreement that you may be entitled to options, which will be governed by the plan, if we're putting actual terms in, we want to make sure that they don't conflict. All key terms should be addressed in one agreement, because if you have a pile of disparate agreements that were signed on different dates, there can be confusion as to what actually governs and whether someone received proper consideration, which I will get into. So we recommend having all the key terms in one agreement or an agreement with schedules attached. I mentioned that ambiguity should be avoided and compliance with the statutory requirements. So some of the ones that we tend to recommend that people include are attaching the Employment Standards Act poster that employees are supposed to be provided, and the safety awareness training that is required under the Occupational Health and Safety Act, and a link to that training. So if we include that in the agreement, we know that people know that we're complying with the statutory requirements. Next slide, please, Peggy. Okay, so enforceability issues. When you're starting off, you obviously want an agreement that is going to be enforceable, and there are a number of things that we consider. The first one, and don't you love it when people throw in Latin, a little bit of Latin just for fun, change of substratum clause. So substratum is a big word that just means the fundamental underpinnings of an employment relationship. If somebody starts their employment relationship in one set of circumstances. So I'm going to use the extreme circumstance that often gets used. Someone starts in the mailroom and you give them their employment agreement to govern their terms in the mailroom, and then they get promoted and gradually promoted and gradually promoted, and all of a sudden they're in a much more senior role. If they don't get a new employment agreement and there isn't a change of substratum clause, then someone can argue that they are no longer bound by the terms of the existing agreement, because that agreement doesn't describe their current employment relationship. The change of substratum clause, which we include in all of the agreements that we prepare, is this agreement will continue to be binding irrespective of any changes to the terms of your employment, notwithstanding the fact that we put that in because we want you to have the choice about whether or not you have to update an agreement. We do recommend that people review their employment agreements every 2 years just to make sure that for a variety of reasons they're still binding, including, as Julia referenced, changes to the law and termination clauses. But it's still a best practice to ensure enforceability throughout the terms of an employment relationship to include a change of substratum clause. Consideration for entering into the contract. So just like any other agreement in Canada, any other contract in Canada, in order for an employment agreement to be binding, you need an offer, acceptance, and consideration. So consideration is something you weren't already entitled to. When someone signs their employment agreement before they start work, the consideration is the compensation they get by virtue of starting work. If somebody signs it after they started work, by starting work, they're already entitled to be paid. So in order for that agreement to be binding, you need to give them something new that they weren't already entitled to. More often than not, that comes in the form of a signing bonus. There is no law on what a minimum amount of consideration, what a minimum there is no law requiring a minimum amount of consideration. We make certain recommendations. For junior employees, it could be anywhere from $100 to $500. And for senior employees, I tend to recommend between $1,000 or a week of salary, but it could really be anything. It could be extra vacation days. It could be enhanced benefits. It could be what have you, anything they weren't already entitled to. Whatever that is, we want to make it clear in the agreement that this is the consideration that they are receiving in order to have that agreement be enforceable. And undue influence. So no contract is binding if people have been unduly pressured to sign it with threats to their health, safety, or economic security. So we want to make sure that people are signing in a circumstance where there is no perceived undue pressure of that nature. And that has been litigated in circumstances where people have been required to sign agreements in order to remain employed. And that is a very touchy area because continued employment is not considered consideration, and the exchange there can be complicated. So of course, if you have any concerns with that, you just give us a shout. We could move to the next slide, please. Okay, key terms and their implications. We recommend including each of these, and I've touched on, I'm not going to do probationary clauses or termination clauses because Julia did them. So I'm going to focus on reference check clauses, entire agreement clauses, and severability clauses. So reference check clauses, and people don't always realize that this can be quite complicated. In seeking references regarding a potential employee, a would-be employer is collecting personal information about that employee. So the rules and requirements about collecting personal information can be quite complicated. And as a result, it's a best practice to obtain consent prior to collecting any information. For these reasons, we recommend including a reference check clause in the employment agreement that includes the fact that by signing the employment agreement, the individual is consenting to, and we include any of the following which are applicable: reference checks. In the modern age, social media checks, which gives you permission to go on their variety of social media pages and see what they've been saying, what their postings are. A criminal record check. You need consent to do a criminal record check. So if you are going to need one or you want one, you need to get the consent in the employment agreement, or any other background information checks. You're also going to want to include, and we include this in our paragraph, the fact that the employer is relying on the accuracy of the credentials or references provided by the employee. A statement that the sufficiency of the references is going to be determined by the employer and in the employer's sole discretion. So the person's not going to turn around and argue, well, my references were great. The decision lies with you, the employer. And that the employer reserves the right, and this one's extra important, reserves the right to withdraw the offer of employment without notice or payment in lieu of notice if references are insufficient or cannot be verified or substantiated. Including this clause will allow would-be employers to do well-advised homework provided prior to entering into a relationship with someone new. If you have any questions about that, just let us know. Entire agreement clauses. So there's something in law called the parole evidence rule, which says that you can't adduce evidence, you can't bring forward evidence about any discussions that happened outside of a written agreement. An entire agreements clause just basically highlights that for a layperson and says, look, if this was the term of your employment, it has been included in this written agreement. There are no other terms. This protects employers against claims of negligent misrepresentation for somebody who then turns around and says, you promised me all these things in the context of my employment, and then you didn't provide them. Having an entire agreement clause basically says, look, we told you all the terms that would apply are in here. And so you couldn't have been surprised that this was not a term of your employment if you didn't find it in your written agreement. Finally, severability clauses, and this keys in very nicely with what Julia was just explaining. Some things change. So, something may be a binding at law at the time of executing an agreement, but just like termination provisions, the law on it can continue to evolve to a point where it may no longer be binding years later. So a severability clause basically says that if anything in the agreement is no longer enforceable, that will be treated as severed, and the rest of the agreement will remain binding, which protects and ensures additional longevity for terms that don't change as frequently and aren't in flux. I should note that there is case law that a severability clause will not necessarily protect an agreement if there's an invalid termination clause, but other provisions can be protected if the invalid provision is not a termination clause. That's a bit of a longer discussion, and with 3 minutes left, I don't have time to get into it, but we'll move on to the next slide. And if anyone has any questions, you know where we are. Okay, so once you've got it all in writing, there are some questions that we may be asking you at the outset to determine whether or not people are in fact employees or independent contractors. This more often than not comes up in the context of people saying, we want to hire someone as an independent contractor, and not just because we call them independent contractors doesn't mean that a court would consider them independent contractors. We have to the court will look at the substantive relationship and the degree of control that is exercised by the person that is seeking the services. And if there is a considerable amount of control, then the person would be deemed to be an employee. The considerations on whether or not someone would be considered an independent contractor. Some of them are included on this slide. Who controls the work? So if the person seeking the services, if the business seeking the services is going to control the amount of work, the nature of it, where the person does it, and how the person does it, then it's more likely than that person would be considered an employee. Which party bears the ultimate risk of profit or loss? So if somebody has a salary, irrespective of how hard they work, they are getting the same amount of income. But if, depending on how hard someone works, they could receive more or less income, they're more likely to look like an independent contractor. Who owns the tools? If the person looking for the services, if the business owns the tools, they're more likely to look like an employer. If the worker owns the tools, they're more likely to look like a contractor. And whether the worker is an integral part of the organization. So someone whose assistance is ancillary, so they're just doing a little bit of marketing assistance here or there, or they're doing a job that isn't fundamental to the functioning of the business, would more likely, you could argue more likely that they are an independent contractor. If it's a key role or an executive role like CEO, that's going to be harder. They're going to look more like an employee. Next slide, please. There are additional considerations I've listed here, and the reason that this is particularly important is that the ESA was updated, I believe it was in 2018. Section 5.1 says that creates a provision that an employer who treats an employee that as anything other than an employee can be subject to penalties under the Act. So we need to be extra careful. And there is an intermediate status of a dependent contractor, which is somebody who is in fact a contractor, but they are reliant on the business for almost all of their work, in which case, upon termination, their notice entitlements are the same as if they were an employee. Next slide, please. So we've already touched on non-competition clauses, and we are at time. Catherine touched on overtime when discussing the class action in relation to that, so I'm not going to touch that one. And the last slide, please, Peggy. We already touched on temporary layoffs, so look at this. I was so on the ball. Vacation entitlements are both to vacation time and vacation pay. There is a difference between the two. You want to make sure that you're adhering to both. And I will get into best practices in the Q&A. That way I don't run too over time. On that note, as I close out, I believe the next slide is the question slide, isn't it, Peggy? So right now we have one question in the Q&A that I wanted to answer personally. Amy, yes, you'll be provided the slides. There is a closeout email that will follow that will include both the slides and the recording, as well as some other helpful information about other Dentons resources. So yes, that is coming. Does anybody have any other questions? And I'll leave it for just a moment. So as we do that, I am also scrolling down to and Catherine prepared a vacation toolkit that kind of explains this very complicated area. So if anybody wants that information, please let us know. But so on vacation, the entitlement, ESA, so if you're provincially regulated in Ontario, your employees are entitled to a minimum of 2 weeks of notice up to when they reach 5 consecutive years of service, and they are entitled to that for every 12-month entitlement period. Upon reaching 5 consecutive years, you are then entitled to 3 weeks. There are associated amounts of vacation pay entitlement. Parties can agree to vary vacation entitlements in an employment agreement as long as they remain equal to or greater than those required under the ESA. And this is a tricky piece. And we navigate this for people all the time. Employees are entitled to compensation for any earned vacation pay that has not already been paid at the time of termination. They are also entitled to vacation pay on all of their wages, which includes more than their base salary. It includes overtime amounts and non-discretionary bonus payments, among other items. So maintaining an accurate calculation and paying out vacation on all amounts is pretty important. And I see there is a second question. Oh, just a thank you. So are there any other questions that anyone has? Oh my gosh, we can do that, Nicole. So Nicole has requested whether we can explain the calculation of vacation entitlements during leave and returning. Is vacation pay owed if there is a top up? I'm going to start this, but then I'm going to throw it to Catherine, who did our toolkit, our client package on this. So vacation pay is calculated based on wages. If somebody on leave is not receiving any wages, they don't have anything to calculate the vacation pay on. So the entitlement would vary. If somebody's off on leave and they're still being paid, then it would be calculated based on the amount of pay they're receiving. If they're off on an unpaid leave, then the vacation pay would be 0. 4% of 0 is 0. 6% of 0 is 0. The vacation time entitlement while on a statutory protected leave does continue to accrue. I'm gonna flip now to Catherine for the more complicated piece of that. Is vacation pay owed if there's a top up? And I note that Nicole is part of our internal team, so if we need to take this offline, we can.
Thanks, Stephanie. Yeah, I mean, you've explained it well. You only pay vacation pay on wages. So if the top up constitutes wages from the employer, there will be vacation pay paid on that. If the top up comes from somewhere else, for instance, if you're talking about EI coverage during a pregnancy leave, parental leave, or a sickness leave, you will not provide vacation pay on those amounts. I will simply add at this point that if anyone has any further questions about vacation and you have not received our Dentons Vacation Toolkit, please do reach out to any one of us. It is not something that we have posted publicly online. We don't want to see employee side counsel use it as a roadmap for claims against our clients. But it is a tremendous resource that we published to our clients last year, and we'd be more than happy to send a copy to at this point in time. If everyone can come back online, we will now thank you all very much for attending today. It was a pleasure to have you all here with us, and we look forward to doing this again next year. Thank you so very much. Bye-bye.